I don't have any questions, but I have a statement. I want to let you know that I'm so sorry about that because I know you've afforded me many opportunities to utilize your library and such, and I didn't take that up. But I do promise you that you'll see me out there once again with City Beat magazine, and I'll try and do everything I can to get you copies of that so you could read all my stuff coming up.
All right.
Really do apologize because I know you used to like to read my stuff in the Border Observer too.
All right. Well, what we're going to do is we're going to proceed on these cases now. And let us go ahead. So this is the state of Texas versus Isaiah Montoya, present in court with his attorney, Mr. Avalar, and the state's attorney, Ms. Espinosa. And I understand we have a plea agreement here. Would you please state that on the record?
Yes, Your Honor. With regard to 2022 0D02782 and 2022 0D02999. And then there is also 2022 0D02998.
Which one?
2998. Well, strike that, Judge. So with regard to the first two, the recommendation is 3 TDC.
Okay. Those are the new cases, not the rebels.
Correct, Judge. That include a third degree felony.
Right.
And then with regard to the state jail offenses.
Now, what's the 2998? Is that the one you're going to dismiss?
No, that is a state jail offense.
That's a state jail.
Yes.
Okay.
And then there's also 2944.
Are these all new cases or revo cases?
These are all new cases, Your Honor.
These are two 2022 cases?
Yes, they're all 2022.
Okay.
And so
Okay.
we have 2944, 2998. There are some state jail offenses under the 2999 cause number 3000, 3001, 3002, 3003, and 3363. And the recommendation on those is
three. What was that last one? 3 what?
3363.
3363. Those are all state jails?
Yes, Your Honor.
So those are 1 year, you said, state jail?
Yes, Your Honor. And those are to run concurrent with the revocation.
And what are the revo numbers?
The revos are, there's 5, 2013 0D0 5106, 2013 0D0 6174,
Okay.
2013 0D0 6175, 2014 0D0 0575. And those are the ones that are being pled to today, but there is another probation cause number, Your Honor, that we're going to have to plead, like you said, next week.
And what is that number?
That's 2017 0D0 0111.
Okay. Now you've given me 4 motions to revoke that we're doing today, 1 that we'll do next week, and then 1, 2, 3, 4, 5, 6, 7, 8, 9 pending charges. And then there's one more. You said there's some one of them something you're gonna dismiss, you mentioned earlier.
Yes, Your Honor, and I'm dismissing 2022 0D0 4590.
Okay. And so on every state jail, it's going to be, you said 1 year in the state jail. And on all of them that are either third degree felonies, I think they're all third degree. If there's any second degrees, I know there's no first degrees, right?
Correct, Judge.
So-
No, they're all third
so-
degrees.
They're all third degrees. Those are 3 years in the Texas Department of Corrections. And then, did you say all of these are going to run concurrent?
Yes, correct, Your Honor. They're already concurrent.
And then he's going to get credit for all the time that he served that I can legally give him credit for under the statutes,
Yes, Your Honor.
which the number is somewhere, it varies possibly with each case, but it's as high as 700 and some odd days in some of them. I don't know. I don't remember, because some of the cases are the old cases that go way back in 2013 and 14. Those cases, he even served some time back there on those. Now, on the 2022s, or the ones he probably hasn't served as much time on, because those are newer cases. But he did get picked up. I don't remember when, but we'll add all of that together. Okay. Now, is that the plea agreement as you understand it, Mr. Avalar?
Yes, sir.
Is that the plea agreement as you understand it, Mr. Montoya?
Yes, Your Honor.
Okay, now you understand the plea agreement's not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, I could withdraw, you could withdraw your pleas and we could proceed to jury trials on all the cases that are under present indictment, and we could proceed to motions to revoke on all of those other motions to adjudicate or motions to revoke cases. But if I follow the plea agreement, it is final. You cannot appeal these cases. You cannot withdraw your pleas without my consent. It looks like on the state jails you've got those times served out. And the only question remaining would be, how much time of that 3-year sentence do you have on the third degree felonies? Now, I can't promise you you'll get all the credit that you're entitled to on those, but I can't tell you then exactly how soon you could be released, because I never do that. That's up to the Texas Department of Corrections, the Board of Pardons and Paroles, to determine when that release date would be. You would be then transferred to the Texas Department of Corrections to serve out whatever, if any, of this sentence they choose to ask you to serve out. Do you understand that?
Yes, Your Honor.
Okay. Now we have in front of us some documents, marked State's Exhibit number 1 in all of the new cases. And in the motions to revoke, we have documents marked State's Exhibits 1, 2, and 3. In the new cases, State's Exhibit 1 are the guilty plea and waiver forms. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign all of those documents?
Yes, Your Honor.
Now, in the motions to revoke, we have stipulation and waiver forms. Again, they bear signatures of your attorney, the state's attorney, and what appears to be your signature. Did you sign all of those documents?
Yes, Your Honor.
With the exception of that one case you haven't signed yet, because we've got to come back and do that one later.
Yes.
Okay. Now, did you read all of those documents before you signed them?
Yes, Your Honor.
Did you understand what you were reading and signing?
Yes, Daniel Avalar helped me understand them.
Okay, because it was a lot of paperwork, but a lot of it was repetitive. A lot of it was the same thing over and over again. But also your attorney explained to you the meaning of the documents.
Yes, and he did a great job.
Thank you.
Well, thank you, Mr. Avalar. So you understood what he told you. Do you have any question about the meaning of any of those documents?
No.
Okay, so that there's never any question, let me briefly explain to you what they mean. On the new indictments, primarily 2 things. First, you're coming into court telling me through a judicial confession, yes, Judge, I did commit those offenses, or was involved in the commission of those offenses as a party under the laws of the state of Texas. And secondly, you're telling me that you understand that you're giving up some valuable rights here today. Most important of those rights, the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. Do you fully understand that?
I do, Your Honor.
understanding that, how do you then plead to all of those cause numbers that are the new indicted cases, guilty or not guilty?
Guilty, Your Honor.
Now, on the motions to revoke or adjudicate, those documents mean basically a stipulation is an agreement between yourself, the state's attorney, and the defense attorney that certain facts are true, which basically is stating that, yes, Judge, I was on probation. Yes, Judge, I had certain terms and conditions I was supposed to follow. And unfortunately, Judge, I did not follow all of those conditions. Primarily, you committed some other offenses while on probation. And then the waiver form tells me you're giving up the right to a fully contested hearing on all of these matters. You understand all of that.
Yes, Your Honor, I do.
Now, understanding that, then how do you plead to those motions to revoke, true or not true?
True.
Are you entering your pleas of guilty and true freely and voluntarily?
Yes, Your Honor.
Did anybody force you or threaten you, coerce you, or in any way make you plead either guilty or true?
No, Your Honor.
Did anybody promise you anything, persuade you in such a manner you felt you had to plead either guilty or true, other than the plea agreement stated on the record in open court here this afternoon? Now, you understand on the state jail felonies, the punishment range is from 6 months to 2 years in the state jail. On the third degree felonies, the punishment is not less than 2 years, nor more than 10 years in prison, a fine not to exceed $10,000. You understand I'll sentence you somewhere within those general guidelines.
Yes.
Now, you are still a U.S. citizen.
Yes.
And how old are you now?
47 now.
And how far have you gone in school?
I have 2 associate's degrees.
All right. And obviously you can certainly read and write the English language.
Yes.
And
As you
have
know,
you ever been under the care of a psychiatrist, psychologist for mental health, mental illness issues?
No.
Suffered any serious head injuries?
No.
And are you presently under any medications for mental health, mental illness issues?
No, Your Honor.
And you're telling me you are mentally competent, you understand everything that's going on here this afternoon?
Yes.
Okay. And Mr. Avalar, you've had extensive time to go over the facts and circumstances of these cases, the legal aspects of the cases, and had time to evaluate your client's mental status.
Yes, sir. Both Mr. Wyatt and I. Yes, sir.
Okay. And so both of you have worked with him long and diligently here, and are both of you representing to me that you believe he is mentally competent to enter these pleas?
We are.
Okay. Then based on your representations, Mr. Avalar, your representations, Mr. Montoya, and the court's observations of you in court, both here today and on several other previous occasions, I find that you're competent to enter the plea. The state may summarize the evidence.
Yes, Your Honor. Had the state proceeded to trial under cause number 2022-0D02782, the state would have proven beyond a reasonable doubt each and every element in the offense of possession of a controlled substance, penalty group 1/1B, more than 1 gram but less than 4 grams, and also the offense of burglary vehicle with 2 or more previous convictions, as alleged in the indictment. And had the state proceeded to trial under cause numbers 2022-0D02944, 2998, 2999, 3000, 3001, 3002, 3003, and 3363, the state would have proven beyond a reasonable doubt each and every element in the offense of burglary of vehicle with 2 or more previous convictions, as alleged in the indictment. And the state moves to introduce in each of these cause numbers listed States Exhibits 1 through 2, which are the plea papers and the 3914 disclosure form. Additionally, had the state proceeded to trial on cause number 2022-0D02999, the state would have also proved beyond a reasonable doubt each and every element in the offense of theft of a firearm and unlawful possession of a firearm by a felon, as alleged in the indictment. The state moves to introduce States Exhibits 1 through 2, which are the plea papers and the 3914 disclosure form under that cause number. And additionally, Your Honor, had the state proceeded to a revocation hearing under cause numbers 2013-0D05106, 2013-0D06174, 2013-0D06175, and 2014-0D0 0575, the state would have proven beyond a preponderance of the evidence that the defendant pled on December 18, 2013, thereafter on January 21st, 2014, and and March 7, 2014, to a term of 10 years deferred probation. Thereafter, committed the offense of possession of a controlled substance, burglary of vehicle with 2 or more previous convictions, theft of a firearm, and unlawful possession of a firearm by felon, as alleged in the previous cause numbers that I just listed. The state moves to introduce in each of those revocation cases states exhibits 1 through 2, which are the stipulations and waivers, and the trial court certification of the defendant's right to appeal.
No objection from the defense, Judge.
Received. Based on the evidence before the court finds the evidence sufficient to find the defendant guilty in each of the new cases under indictment, and I find the evidence sufficient to find the allegations true, and I find them true in regards to each of the motions to revoke or adjudicate, and I revoke the defendant's probation in those cases, and I'm now ready to proceed upon the issue of punishment. Now, Mr. Montoya, I know that you have struggled with some issues, particularly drug, alcohol issues for a long time. I don't know how much treatment there is. I know there is some treatment at the Texas Department of Corrections. I hope you avail yourselves of that. When you get out, what is your plan?
I plan on continuing writing for City Beat magazine, and I'm going to attempt to write for some other magazines. In addition to that, I do want to continue going to NA, because this has just been truly unfortunate, because I did really have another chance out there. So I really want to let you know that I'm going to make you proud, because I know you have a lot of confidence in me and my ability since back in way back in the day in 2007, 8. And I'm still young enough to make it happen, and I have confidence that it's going to happen. So I thank you for the opportunity, actually.
Well, it's unfortunate that in one sense that part of this has to end in incarceration, but that, like I said, it looks like that incarceration won't be a whole lot longer. Maybe you've had unfortunately a long time to reflect on this, and I think you're a reflective person. You're an intelligent man. You have a lot of skills and a lot of abilities, and sometimes you've used them very, very wisely and done well with them, and unfortunately other times you've not used them wisely, and you've unfortunately faced some difficult consequences. You can still make a great life out of it. 27 years old, there's a lot more to go through, a lot more to do. You can make a lot of great things happen for yourself and maybe for others. And
yes,
I hope that.
I want to inform you that I'm actually engaged for the first time also, and I think that'll help me with stability and such. I've never been married or had a kid. That should help. So I appreciate it.
Well, that's good to know that you're engaged, and so that'll be good. When you get out, are you planning to come back to El Paso or New Mexico, or where do you intend to go?
Well, I love covering stories here in El Paso. There's never stories to run out of. So I mean, I love it.
All right. So when you get out, I guess we'll see you back here, and hopefully you'll do well. You've got to be very careful now.
Yes.
Because this is a long criminal record, and now I think you'd been down once in New Mexico, right? I think, and now once in Texas. That's 2 priors, and a third one could result in a very long prison sentence, because that's you could be potentially habitualized. That's why I'm warning you to just be very careful not to commit other offenses, because it could then you wouldn't be looking at a 1 year, 2 year, 3 year type sentence. You'd be looking at a very significant sentence that would take away a lot of your life, and that would be a terrible waste. And I don't want to see that happen. I'm sure you don't want to see that happen. I'm sure your fiance doesn't want to see that happen. And so, like I said, the road you choose is up to you. Like Robert Frost said, the two roads diverged in a yellow wood, and You're going to have to take one or the other. And I hope you take the good one.
I will.
And you take the high road and the good road, and you become a productive and, honorable citizen that I know you can be. And I hope it all works for you. So I will follow the recommendation. 1 year to serve on all of the state jails, 3 years to serve on the third degree felonies. I run them all concurrent. I give you credit for all the time that is allowable under the statutes to give you. And we'll come back next week and conclude the one case, and we'll run that one. That's the state jail. It'll be 1 year, and we'll run that one concurrent with it too. So good luck to you, sir.
Bless you, Your Honor.
Thank you. All right.
Thank you, Judge. May I be excused, Your Honor?
You may. Okay, let's proceed with let's see, who's here. Do we have, who's going to do Mr. Campos?
Judge, I am.
Okay, you're going to stand in for Mr. Vargas?
Yes, Judge, but really briefly, this was continued from last week because we didn't know exactly where he was going to go. I reached out to the reentry services, and they haven't confirmed yet that the rescue mission has a bed available for him right now. So as of right now, he still doesn't have. They will transport him there, but I'm not sure if he'll stay there or they might have him go to the opportunity center or somewhere else. Yeah, that's I just asked again right now for a most recent update, and that's the most recent update. They did ask though that upon his release, if the order can say to please have him be transported by the sheriffs to the rescue mission directly.
Is the rescue mission, like you said, ready to receive him or not?
There hasn't been confirmed, no, Judge. They reached out to the rescue mission, I guess the person in charge, and they haven't come back saying we have a bed available for you yet.
Let me before I do this, I don't want to have a problem. And I know the person at the rescue mission that runs it. Well, I want to talk to him, and maybe I can facilitate getting him in there quicker, because I'd rather do that than just, okay, they say if they won't take him, or they might take him, but if they don't take him, they might take him somewhere else. But what if they don't? Then what happens to him? That worries me.
Yes, Judge. I also was able to get an appointment for his mental health as soon as, when he gets out, he has an appointment already scheduled for the 13th. That's this Monday at 2:00.
Okay. I'm thinking.
And it can be rescheduled if it has.
Yeah, I want to reschedule this one. I'm going to keep this card on my desk. I'm going to call the people at the rescue mission directly when we get done today.
Yes, Judge.
And try to redo this, because I just don't want him to fall through the cracks. Because if he does, not only would it be bad for him, it would be bad for society.
Yes, Judge. I also tried to, before I reached out to the rescue mission, I tried first to contact family and see if anyone would be willing to take him, but that was he didn't have adequate.
No,
I
understand. Okay. Then we'll have to reset.
Thank you, Judge. May I be excused?
You may. Let's do Mr. Is Mr. Spencer here?
Judge, I'm on the line with them. I believe they said that they have a new offer that.
Yes, Judge, the negotiations fell apart today. And so I thought we had a deal, but make a long story short, we're still, I think he needs to talk to his client again.
All right. Not a problem. We'll reset that one and come back, and we'll see if either that or we'll try it. We'll do one or the other. Okay. Then I do know we have one plea left on. I want to do that last plea before I go to the bonds. That's on Mr. Doolittle. And that's with Mr. Morales. Okay, this, it must be cause number 2022-0D05096, State of Texas versus Jeffrey Doolittle. Is that your true and correct name, sir?
Sorry, yes, sir. Yes, sir.
Okay. And your date of birth, 3/30 of 1980,
Yes, sir.
and you recognize your attorney there, Mr. Morales?
Yes, sir, I do. Thank you.
And Mr. Morales, you recognize your client, Mr. Doolittle?
I do, Judge.
Okay. Now, I understand with plea agreement here. Ms. Espinosa, would you like to state it on the record?
Yes, Your Honor, it's to the lesser included offense of possession of a controlled substance, penalty group 1, under 1 gram. And it's to 120 days.
120 days county jail.
And I believe it's under 1244A, Your Honor.
1244A. All right. And let me look here. Mr. Doolittle has credit for 100, looks like 131 days. So this is a time served plea, correct? And
Correct.
unless there is something else holding him, which I do not know, but if there's nothing else holding him, that would release him from jail, correct?
And Judge, there's some parole issues that Mr. Doolittle is still dealing with, so it's not
Okay.
clear that he'll be absolutely released.
Okay, so he's got a couple of parole. Yeah, that's right. He was at that facility, so that indicated he was on a parole. But it resolves this case,
It does, Judge.
and then whatever parole decides to do, they will do. Okay, is that your understanding of the plea agreement, Mr. Morales?
That is my understanding of the plea agreement, Judge.
Is that also your understanding of the plea agreement, Mr. Doolittle?
Yes, sir. Your Honor.
Now, I have in front of me some document. Oh, first of all, you understand the plea agreement's not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, you could withdraw your plea. We could proceed to a trial on this matter at a later date. But if I follow the plea agreement, it is final. You cannot withdraw your plea. You cannot appeal the case without my consent, and you would begin, I guess that would be the end of the case. It would be the only additional problem from this case would be that this would now appear on your record, looks like under 1244A as 120 days in the county jail. You understand that?
Yes, sir, I do, Your Honor.
Okay. Now we have in front of us some documents marked State's Exhibit 1, the guilty plea and waiver forms in this case. Well, before I go there, you understand that, but if I do follow the plea agreement, you cannot withdraw your plea. You cannot appeal the case without my consent. And then this sentence would be finalized and formal. You understand?
Yes, sir, I do.
Okay. Now we have in front of us some documents marked State's Exhibit 1, the guilty plea and waiver forms in this case. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, Your Honor, I did, sir.
Did you read them before you signed them?
Yes, sir.
Did you understand what you were reading and signing?
Yes, sir, I did.
Did your attorney further explain to you the meaning of the documents?
Yes, he did, Your Honor.
And did you understand what he was telling you?
Yes, sir.
Do you have any question about the meaning of the documents?
No, sir.
So that there's never any question, let me briefly explain to you what they mean. Primarily two things. First, you're coming into court telling me through a judicial confession, yes, Judge, I did commit the lesser included offense of the possession of controlled substance under 1 gram. And secondly, you're telling me you understand that you're giving up some valuable rights here today. Most important of those rights, the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. Do you fully understand that?
Yes, Your Honor.
Understanding that, how do you plead then to this lesser included offense, possession of controlled substance under 1 gram, guilty or not guilty?
Guilty, Your Honor.
Are you entering your plea of guilty freely and voluntarily?
Yes, sir.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No, sir. No.
Did anybody promise you anything or persuade you in such a manner that you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
No, sir.
Now you understand the potential punishment under 1244A is from 1 day to 1 year in the county jail, a fine not to exceed $4,000. And you understand I'll sentence you somewhere within those general guidelines.
Yes, Your Honor.
You are a U.S. citizen?
Yes, Your Honor.
And how old are you, sir?
Sir, I'm 43 on March 30th, sir.
So 42 today. And how far did you go in school?
I graduated on the 6th grade level, sir. 1999.
Are you able to read and write the English language?
Yes, Your Honor.
Have you ever been under the care of a psychiatrist or psychologist for mental health, mental illness issues?
Yes, sir.
What types of issues?
Emotionally disturbed, ADHD, hypertension, special ed.
And are you presently under any medications for mental health, mental illness issues?
I was on the anxiety, but I haven't been taking it. So just been up one day at a time. So, you know.
Have you suffered any serious head injuries?
No, sir.
Are you telling me you are mentally competent this afternoon? You understand everything that's going on here?
Yes, Your Honor.
And counsel, you've had time to go over the facts and circumstances of the case, the legal aspects of the case, and had time to evaluate your client's mental status.
I have, Judge.
Based on all that, are you representing to me that you believe he is mentally competent to enter this plea?
I believe he's mentally competent to enter the plea, Judge.
Then based on your representations, Mr. Morales, your representations, Mr. Doolittle, and the court's observations of you in court, both here today and prior occasions, find that you're competent to enter the plea, that the state may summarize the evidence.
Yes, Your Honor. Had the state proceeded to trial in this case, the state would have proven beyond a reasonable doubt each and every element in the lesser included offense of possession of a controlled substance, penalty group 1, as alleged, not as alleged, but the lesser included, Your Honor. The state moves to introduce state's exhibits 1 through 2, which are the plea papers and the 3914 disclosure form.
No objection to their introduction, Judge.
Received. Based on the evidence before the court finds the evidence sufficient to find the defendant guilty of the lesser included offense of the possession of controlled substance under 1 gram. And I so find. I'm ready to proceed upon the issue of punishment. Mr. Doolittle, when you get done with the parole issues and everything, what are your plans?
Your Honor, I'm gonna go back to 83-year-old Larry Lococo, veteran brother on the southwest side. I've already got a place, charge 8 to 14. I'm gonna head up a ministry school.
Okay.
I give it all I got, Your Honor, and everything I can in society to make society better. And thank y'all for everything y'all do. You know, job. God bless you.
All right. And do you have family or?
I actually do. My mom, Mahela Hamlin Doolittle, dad's inheritance. He passed away last year. It hit me hard.
All right. Well, it's good to see that you are ready to make some significant changes at, 42, almost 43 years age. It's, hopefully you'll be able to do something. What kind of work have you done in the past?
Well, I've worked at Hands Flying J's, detail cars, work on cars, and do little sparkling detail. Do little, let me do little.
All right. Well, I will follow the recommendation, and it's 120 days in the county jail. It's time served so that resolves this case, and as soon as you resolve your issues with the, I guess, the Board of Pardons and Paroles, you will be back out and hopefully some good things can happen for you.
Yes, Your Honor, and I really appreciate it. I'm gonna do everything. Ask
All right.
that people see a change in my life and that know that we can change and that Jesus changed.
Well, that's true, that change is always possible. And so the biggest thing will be, probably the drug stuff has haunted you for a long time, and, get some treatment, and it's hard to go that road alone. And so, get some help, and there is some help out there, whether it's AA, NA. So good luck and take care of yourself.
God bless you, Your Honor, and thank all
Thank
y'all.
you. Well, same to you, sir.
Y'all be great.
Okay. All right. Let's proceed on to Mr. Is it Crimer?
Criminal. Criminal.
Kremer. Okay.
Criminal, right. Like trimmer, but with a K.
Right. All right. I believe this is cause 2022-0D05563 and 2022-0D05823. These are burglary of building, burglary of habitation charges. It looks like the defendant has been in jail for 115 days. What is the bond presently set at?
The bond, Your Honor, is, well, in Mr. Crimer's case, it doesn't really matter because what he can afford is $200 or $500. And so Mr. Crimer has been very persistent in trying to secure his release on a reasonable bond. He did provide addresses and phone numbers of people who might be able to assist him in a place to stay, because he has no place to stay. But in reaching out to both those individuals, it just fell apart. There was nowhere for him to stay. So I'm here to present a bond petition at Mr. Crimer's insistence and sue that. Importantly, they got these cases and some misdemeanor cases, and I've reached out to ADA about the likelihood of resolving these cases as misdemeanors. Although Mr. Crimer does present with a history, I believe these cases are not so egregious as to pursue penitentiary time. And so that's what we're here on, Your Honor, a bond petition that I would acknowledge is fraught with all kinds of negative headwinds, so to speak. He was in a PR bond, he violated PR bond, but he's been in jail a while. And so I bring that petition to the court. But the other is, been really trying to negotiate this case, and I've emailed Ms. Espinoza in that regard a few times. And so that's what we're here on.
All right. Yeah, what is, let's see, what is the bond actually set at in each case from the,
Judge,
you know? Yes.
on the 5563, it's 5,000 surety. And he's also detained on another case that it's not on the docket. 2022-0D0 5823. And that bond is at 15,000.
So it's 15,000 on the burglary of habitation, 5,000 on the burglary of building.
Yes.
And we had a PR bond violation. And what was the reason? Why was the PR bond revoked? Was it for the new offense, or was it for not reporting, or what was it?
Both. Both, Your Honor. Both.
New offenses and not reporting. Now, the defendant is not from here. I understand he was originally from somewhere like Idaho or somewhere like that.
He's not from El Paso. I might have said Idaho, but I might have been thinking of another individual. But
Okay.
Mr. Krimmer can tell us where he's from.
El Paso, Texas.
There you
From
go.
where?
El Paso, Texas.
Now, the other problem, as you mentioned, is that he's done penitentiary time twice, one federal time on a drug case and one TDC time here in Texas for an ag robbery. So they could literally habitualize him, at least on the burglary of habitation, which would be a minimum of 25. Now, whether they do that or not, I don't know. Is it already habitualized indictment or not?
No, Your Honor.
Now, I don't have a combined rec yet.
No, Your
Do
Honor,
you-
and yes, I'm sorry. I had to just make sure that we had notified, even though on the indictment, I think we do allege the previous, and so it could be enhanced. The burglary of habitation could be enhanced. Our complaining witness is telling us that there were some damages. However, and he's going to send us some receipts. This was in March. This was just in March, so he is still on board to prosecute. However, it seems like Mr. Kummer might not have the funds. And so at this point, I'll make a recommendation of 3 TDC on the burglary of habitation and 6 months state jail on the burglary of building.
3 TDC on the burglary of hab, where you could have gone 25, but you're not. And then on the burglary of building, it's how much on the state jail?
6 months state jail, Your Honor.
All right. So what additional evidence would you like, other than things you've already stated, Mr. Solis, would you like me to hear? Or is there anything that your client would like to tell me?
What I wanted to hear, I'm sorry. What I wanted to hear was from what I just heard from Espinosa. So as far as the bond petition is concerned, I have nothing to add.
Okay. You had something else you want to add, sir?
Yes, sir. On the damages, I'm not responsible for those.
Oh, don't go into the facts of the case, though. That's
I'll take the deal. But is there any way I can get like 30 days so I can sell my assets so I can have some money to go to TDC, like turn myself in, if possible? I'll take the deal.
I'm not sure. I don't usually do that.
Just want to see
So,
my
so what I'll do is I'll go and discuss with Mr. Krimmer what he just heard. And then I'll reach out back to Mrs. Espinosa, Your Honor, and then we'll set it for something with the court.
All right. Yeah. Okay. It was a very reasonable recommendation,
Yeah.
given.
I think what Mr. Krimmer is suggesting is some sort of furlough, and then he sells assets and he comes back to plead. But so there it is, Your Honor. That's what's
Well, it's unusual for me to do something like that, but let's.
Sir, if I may say something. If
Yes.
I promise to not mess up, and if I mess up, you can give me the max.
Like life imprisonment.
Life in prison if I mess up. I need 30 days. Or however you gotta give me. I give my word that I won't mess up.
All right. Well, we're going to think about that. I mean, I've done that a few times, and most of the time the defendant shows up, but
Yes, sir.
there have been a couple of times where they didn't, and
Not me, sir.
but they were very unhappy when they ended up serving like 20, 30 years on what they would have served 2 or 3.
Right.
So,
It's just I want to meet my daughter. That's why before I go to prison. It means a lot to me.
all right. Well, let's see. You want to meet your daughter?
Yeah, she's here in El Paso.
Okay, well, let me think about some ideas on that. Because,
Okay.
you know, there's a chance that we could, you know, the other thing we could do is, you know, when we come in and if we do the plea, you know, we can make sure she was present, you know, and I usually always let somebody see their family and things like that. But talk with your attorney a little bit and we'll see what we're gonna do. All right? You know, I obviously, I'm not gonna, you know, lower the bond at this point. But looks like we are going to resolve the cases. So thank you very much.
Thank you, sir.
Okay, let's talk next to Mr. Would it be Thrasher?
No, I think that was Benjamin Brock.
Yes.
Judge. I think wait a minute, he's logging back in.
Okay. That's Mr. Mayor. And then you have the last one, I think, Ms. Garcia, Mr. Morales. Is that right?
What's that, Judge? I'm sorry, I missed that, Judge.
I think you have the last.
Your Honor,
You have Ms. Garcia. That's our last one for the afternoon.
That is correct, Judge, and I got some updated information on the Alas Nuevas.
Yes.
Sending her to. Well, some other updated information from Mr. Pena as well, so.
Good. All right. Let's proceed with Mr. Benjamin's case there. That is, oops, hold on.
Mr. Thrasher, good afternoon.
Mr. Thrasher. Okay. Yeah. This is, looks like cause number 2022-0D04850, State Texas versus Brent Antonio Thrasher. President Court with his attorney, Mr. Benjamin. There was a pretrial conference way back in, well, not way back, but just about a month ago. And I see that there was a wreck there. What is the, see, the defendant's been in jail 160 days jail. And what's the bond presently set at?
50,000, Your Honor. And it's my understanding from Mr. Herrera that essentially, well, it was originally set at 100,000, Your Honor, it was reduced to 50,000. We understood that the family was able to post that. The family is not able to post that. And so we're back.
Did we do a hearing in front of me on this before?
January 27th is my understanding, Your Honor.
And I reduced it from 100 to 50 because they said they might be able to, they thought they could make that, but then it turned out they couldn't.
This was out of the JMAG.
Oh, that was a JMAG.
Yes.
Okay.
January 27th, that was JMAG.
Thank you. I just have a bond hearing.
Okay. All right. Now, what are the alleged facts here, Ms. Espinosa?
Oh, Judge, yeah, I thought we had basically this is a port of entry stop on September 19th of 2022.
When?
September 19th, 2022.
Okay.
9 a.m., approximately 9 a.m. The Bridge of the Americas port of entry on Paisano. The defendant was stopped attempting to cross 2.4 kilos or 5.3 pounds of cocaine. Wrapped in black tape hidden in driver and front passenger seats of the vehicle, which makes it a minimum 15 TDC.
Caveat to that being if they prove he knew it, I think, but I've never gotten any court to bite off on that, Your Honor.
Yeah. So it's a minimum 15 TDC, but I see that you gave a rec of 10. In other words, you might let him plead to a lesser.
Yes, Your Honor.
But he might want to reject that and he might want a trial. Okay. But it's 5.3 pounds cocaine. What's his criminal history?
From what I saw in the rap sheet, Judge, in California, Merced, California, 2009 burglary, 120 days. And then unfortunately, I can't see the history on this other stuff, but 2010 grand theft, just as grand theft, which is a felony.
What year?
2010. 2011 embezzlement. I don't have a disposition for these, Judge, so they may or may not have been pled to. Although I do think that something was pled to because there's a parole violation in 2015.
Looks like he might have already been to prison once.
This was, yeah, and this was in New Mexico. He got a year and 11 months, it looks like, according to the rap sheet. And then in 2016, I can't tell if it's the same embezzlement charge, but it said 2 years, 11 months. And then in 2021, an armed robbery, ag assault with a deadly weapon, unknown disposition.
Where was that?
Alamogordo, New Mexico.
That case could even still be pending. We don't know. All right. Okay, so Mr. Benjamin, what are his contacts to El Paso? It seems like he's got contacts in California and New Mexico, but not here.
Your Honor, he has contacts in Albuquerque. He's from Albuquerque and had been residing in Albuquerque. He has and my notes just disappeared. I apologize. He has an apartment in Albuquerque. He lives with his girlfriend, 2 kids. They're 12 and 5 years old. And prior to being in custody, he was a store manager at Subway and did roofing work in Albuquerque, Your Honor. And so we suggest that clearly he hasn't been able to post the $50,000 bond for the last month. I guess the burning question in my mind is why, if it was a 5-kilo drug case that came through the port of entry, why it's not a federal case, other than there's a huge hole in it.
I don't know. Maybe
Well,
it's not big. Maybe it's not big enough for them. I don't know. Sometimes they have. That's 5 pounds seems like a pretty fair amount.
Well, anything over 500 grams is a 5-year mandatory minimum, Your Honor, and so those are charged regularly.
No, I don't think 50,000. What your opinion, Miss Espinosa?
Your Honor, I'm considering the defendant's criminal history and lack of ties in El Paso, and considering the minimum of 15 TDC that he's looking at in this charge, I think he's a flight risk. And so
that's not even going into the fact that that's a 15 minimum, not considering if you enhanced it. It looks like there may be some pen packets in here. I don't know.
Correct, Judge. We could enhance this still. If we could get the judgments. But I honestly just feel like he is a flight risk. Like I said, he obviously has criminal history in other jurisdictions, and for that reason alone, I would say that we would request that the bond remain the same.
Your Honor, the one thing I would point out, Your Honor, if I may, the one thing I would point out is that Ms. Espinosa did recite several or multiple arrests, but none of those were failure to appears, as far as I understand it.
No, but it's a serious, a fairly large amount. It's a fairly heavy sentence, not counting what they could do on enhancement. Very few no local ties. I mean, Albuquerque's not a huge distance away, but still, I don't think 50,000 is excessive given all those facts. So,
will the court entertain one last argument that there's a story the court tells about somebody in the 1880s going to Albuquerque to look for witnesses?
Oh,
there's contacts in between. I don't remember what the story was, Judge, but somebody was involved in a shooting and they were going to go find eyewitnesses in Albuquerque.
Well, maybe so. But I don't.
Okay.
But I'm gonna deny it at this time. I just feel that I think 50,000 is appropriate. But thank you very much. Okay.
Your Honor, is there a chance I could be put in a breakout session if I'm the last individual?
If you would be, but I've got one more to do.
Okay.
And then once I do that one, you can, if you stay around, we can go into a breakout session. Okay.
Will do.
So
Your
let's do Miss Judith Garcia. She's been waiting here for a long time. All right. This is, let me see what case. It's 2020-6369 State of Texas versus Judith Garcia. And now, oops, hold on, let me go back here. She's been in jail like 135 days. And what's the amount of bond?
And Judge, on this one, this was where we were trying to place her with Viva Maria,
Yes, I remember. I've got lots of notes on all that.
where that was a negative on that one, and we
Yeah, we weren't able to do that. I know we tried.
and we have a bed for her available at Alas Nuevas. Miss
What
Espinosa,
is-
teasing my
what is-
pronunciation?
Wait, I mean, have we addressed the new charges that she has? Because she just picked up a Mandel, a first degree,
Where?
under 2023 0D0.
2023 0D0 what?
Give me 1 second, Judge. Where is it? I think it's 40469.
And I apologize, Evelyn, I did not realize those new cases had been
That was a
indicted.
man delivery, how much?
It's over 4 under 200.
4 to 200.
I'm sorry, Judge. And then, so there's several, she picked up several new charges. There's 2023 0D00633 also.
What's that one? 0D0 what?
0633. That's the manufacturer and delivery. I apologize, Your Honor. The one that I gave you before is an unauthorized use of vehicle.
Oops. Wait a minute. So the other one is unauthorized use motor vehicle. And this other one is Mandel.
Penalty group 1, over
4
4 grams, less than 200, and it's entails fentanyl.
Yeah, let me look through my notes here because I know we've.
So
Okay, yeah, back when we looked at the case,
these are old.
I show way back in September 30th of 2021. It said there is this new indictment alleging a date of 9/1 of 2021?
Yes, Your Honor, it is.
Okay, yeah, so we've gone over the facts of that case back on 9/30 of 21. And it was more like 4.2 grams meth, 4.11 grams of fentanyl. There was a co-defendant in that case.
I guess my concern, Judge, is she has all of these cases pending and we're about to release her. Everything's been filed. if she's gonna accept probation in the long run, I would prefer to have her on probation because she seems to have issues with drugs.
And Judge,
I show that, yeah, I show here that it looked like, yeah, you all were aware of the new cases. And it's still, that you were looking for a still needed to be indictment. It looked like you were gonna give her a, probably still a deferred probation with like inpatient. Now, go over with me, what is this new, what's this facility?
and it is a new transitional living facility that has, I guess, drug treatment, and they
What's the name of it?
Alas Nuevas. I think Ms. Espinosa might even see, she's teasing my pronunciation on that one again, Judge. I can see her smiling. I can see it.
Yeah, I'm just smiling. Can't
Okay,
smile.
Alas Nuevas,
Not
and it's a
smiled all day.
transitional living center, and it's one that you said her mother has looked into too, or what?
Or actually, my social worker here, Miss Alex, what's Alex's last name? But our
Ruiz.
social worker here had looked into it, and we found out that there was space there, but that it was going to take about 2 weeks. Alex Ruiz, it's going to take about 2 weeks, was the information I got today before they would be able to have her enter their facility, Judge. And Miss Espinosa is right. There are a number of cases, Judge, and I know normally we'd be concerned about releasing someone, but in this instance, she's actually already on probation out of Carson County, Texas. We're still dealing with a hold that has recently come up from Carson. So she is already on probation, and if she did not have if pending cases didn't motivate her to stay in line, then certainly the case that she's already on probation for out of Carson would definitely provide the additional encouragement to make sure that she didn't get into trouble. I just gotten the copy of that hold, I guess, from Mr. Pena this morning. Judge.
But in the interim, like this 2 weeks, where would she be staying?
And Judge, I would have to get the address from.
Is it like with her mother?
From Miss Garcia, because I was thinking we were going to move her into the facility, but I think Miss Espinosa wants to. Can we do even a plea even earlier?
Well, I don't see why I kind of looked along with Miss Espinosa. I kind of agree with what she said. Why don't we do the plea and then get her into that facility and start getting some treatment? You know, that seems like that'll work.
And I think Miss Garcia is in agreement with that as well. I think it was just a matter of how long those cases had been sitting out there. So I guess we're fortunate that now those cases have now been indicted. So I think we can wrap up.
Let's set it up for a plea next week.
Are there any pending cases still out there, Evelyn?
No, I didn't see anything else.
Yeah, that was. I knew that we've been kind of waiting on those, and unfortunately
Now, one of the terms and conditions out for sure is there's a couple of co-defendants in some of these cases that I wouldn't want her associating with. You understand, Ms. Garcia?
The co-defendant he's locked up. I don't talk to him anymore. I haven't talked to him for over a year.
Okay. Well, now, are you able to go back to your mother's or not?
Yes, sir. With my mother or my sister, they live like 2 minutes away. I was staying with my sister before I came.
You're staying with your sister?
Yes, they live 2 minutes away from each other.
Okay. So if we do the plea next week, we could do that and then get you into the Alas Nuevas. You feel comfortable going there?
I don't feel like I need help for my drug use. I've been sober for a year, but yes, if it's gonna get me out, I'm working already. I was already doing good working, but I had work. They let me out with warrants, so I had to come back. But
yeah,
I feel like I need help.
Yeah, they usually let you out to work, but I really, we want to make sure that you get some treatment so that you don't relapse into some drug issues. I think that's what Ms. Espinosa was concerned about. You know, both methamphetamine and fentanyl are very difficult drugs to deal with. So let's try to set that up for a plea for next week, and we'll take care of this then. All right. Maybe by then that facility will have their bed available and we can go straight there.
Find out exactly what the exact time frame that they'll have availability. I'll find that out, Judge.
I mean, because we do, you know, if once you're on probation, the probation department itself has some treatment for drug addiction issues. I mean, they'll give you some help too. And then now, do you have a job? You have a place where you'll be able to work again when you get out?
Yes, sir. At the Motel 6 on Loma Land.
Is that where you'd been working before?
Yes, sir.
Is that in the area where your mother and sister live?
It's about 15 minutes or so, maybe less, like 11.
Motel 6 on Loma Land? And is that like in housework or what is that?
It's at the front desk. I spoke to my manager and he said if there wasn't like work available for the front desk, he would move me to another hotel. That was fine.
Oh, so do front desk work?
Front desk, yes, sir.
Okay. All right. Well, that sounds like that's a plan. Let's work with that. Yeah, there's no need to do anything on the bonds at this time because we're going to do a plea next week. So let's just do that. Let's set that up. All right. And then like I said, we'll get you hopefully some good treatment and, you know, get back out and start working again and get back with your family. And hopefully some good things will start happening for you. Okay?
Yes, sir. And then I have a question.
Yes.
How long is Alas Nuevas for? Or how is it?
Well, ask Mr. Morales and then we'll let him tell you. I'm not sure because I've not dealt with them.
I'll get a chance to explain it to her in some detail there, Judge, because I'm learning about the program myself. I had not heard of it before. So.
All right. Well, I hope it's a good one. I've not heard of it. And get that information to Ms. Espinosa of what they are. Because, you know, if they're a good program, I'd like to use them.
Yeah.
If they're not, then that's a different story. All right.